So our next set of speakers is on the significance of international tribunals. So we will have first off Rebecca Shute. Rebecca is an international lawyer and democracy and governance practitioner with over 15 years of experience spanning the non-governmental, intergovernmental, and private sectors. Her career has been devoted to advancing human rights, democratic processes, and the rule of law across 5 continents. Rebecca's extensive background includes nearly a decade with the National Democratic Institute, where she played pivotal roles in promoting democracy and governance programs in Central and Eastern Europe, as well as Southern and East Africa. Neshan Gunasekera is a prominent international lawyer, educationist, leadership coach, facilitator, and environmentalist from Sri Lanka, with a strong commitment to environmental protection and holistic experiential learning. He's made significant contributions to those fields. He is currently serving as a visiting fellow at the Raoul Wallenberg Institute of Human Rights and Humanitarian Law in Sweden. Nishan's careers spans advisor roles with international organizations, including the United Nations agencies, and active engagement in various international associations. He's received recognition for his work, including the H.E. Judge C.J. Ware Mandry International Justice Award in 2020, and continues to contribute his expertise to peace building, conflict transformation, environmental conservation, and education projects worldwide. Finally, we have Mr. Alyn Ware. He is a peace educator and international peace and disarmament campaigner. He is originally from New Zealand and has lived in the United States and Switzerland, now residing in the Czech Republic. Mr. Ware is co-founder and global coordinator of Parliamentarians for Nuclear Nonproliferation and Disarmament, Peace and Disarmament Programs Director of the World Future Council, Director of the Basel Peace Office, and International Representative for Aotearoa Lawyers for Peace. He previously served as executive director of the Lawyers Committee on Nuclear Policy, and he is the founder slash director of the Mobile Peace Van Schools Outreach Program in New Zealand. He is also our newest or new interim executive director at World Federalist Movement Institute for Global Policy. So a big welcome to you, Alyn, and thank you all 3 of you for preparing this presentation. So I'll hand it over to you.
Thank you very much. I think I'll start and introduce. I've started the screen sharing, but it doesn't seem to be working from my end. Do you see the screen, the slides from your end?
Give it a click. I think it's too zoomed in. Oh no.
There we go.
That's
Thank
me.
you very much. Okay. So I'll give an introduction to the topic, the significance of international courts and tribunals. Then we'll hear from Neshan, who will do a bit of a deep dive into the International Court of Justice. Then Rebecca, who will look at the International Criminal Court, and then we'll have a bit of an overview of some of the other international tribunals and regional tribunals as well. Here you just see a couple, 3 of the tribunals that we're going to be addressing in the presentation today: the International Court of Justice, the International Criminal Court, and the International Tribunal on the Law of the Sea, and a little bit more about the 3 speakers. So as I mentioned, we'll have an introduction first about why it's important, international tribunals, focus then a deep dive more on the International Court of Justice and the International Criminal Court, a focus on some other courts and tribunals, and then look to the future, which is also looking at proposals for additional tribunals to complement the existing ones. Now, just to give you a little bit of an idea, that the international tribunals are not standalone, and that's not the idea of them. They're supposed to be set up complementary to regional courts, also to national judicial systems, and even local judicial systems. So it's part of a matrix of building the reliance and use and application of international law and judicial processes to help resolve conflicts peacefully. These There is some gaps, though, which is why we're going to be looking at a lot more at the international system of tribunals and not so much at national, and a little bit on the regional tribunals. But here are some of the logos of the tribunals that we're going to be looking at today. So firstly, why is it important to have these international tribunals? Well, because they are involved in applying law and legal process to the application of international conflicts and critical issues that are of importance to humanity. Without the use of international tribunals in these conflicts or in these international issues, usually it's the most powerful who wins. What the tribunals do is they focus more on the facts and on the law and in resolving the issues. And so in a sense, they depoliticize the issue, not entirely, but to a large degree. They provide a lot more space for an equal playing field for the various parties, and they help to forge solutions to uphold the rights of all. In addition, they're providing a third-party process, which is really important because that can help disputing parties to find some mechanism, some way to be able to move forward and come to some agreement together, when if they're just in a conflict between each other, that's very difficult to do. But finally, and this is what we say is the proof is in the pudding, not just in the ideas, the proof is in the pudding is that the decisions of international tribunals are generally accepted by all parties and implemented. Even when there's very highly disputed issues coming into the cases, and even when sometimes there is like a clear winner and a clear loser, many times it's more nuanced than just a clear winner and clear loser. Many times the tribunals are finding ways of addressing the rights of all parties, and it's a nuanced result. But even when there's a clear winner and a clear loser, generally the losing side at some stage, it might not be immediately, accepts and the decisions are implemented. So the proof is in the pudding, and we'll come a little bit more to that when we look at some of the examples. So what is it that the tribunals are actually dealing with? As I said, they're dealing with the facts and the law. And so the question is, well, what is international law that they're dealing with? And it's not all the same. I think the broadest body of law that has been applied in the tribunals is that's applied by the International Court of Justice, and it's outlined under the UN Charter and the International Court of Justice Statute, which was adopted in 1945, 1946, part of the UN. Then we have some other key tribunals like the International Criminal Court, where the law complies what was agreed in the Rome Statute, but there's some supplementary principles of law that sort of come into play as well, and Rebecca will talk a bit about that. And the International Tribunal of the Law of the Sea, it's the UN Convention on the Law of the Sea. But again, there are some principles of law dealing with the oceans that are supplementing the convention, that have some play in the tribunal. And the Permanent Court of Arbitration, these are now updated. The Permanent Court of Arbitration was the first of these tribunals, but its rules were updated in 2012 to look at how the Court of Arbitration works and what rules it should apply. Now, of course, there are other tribunals that also have other bodies of law that are applicable, but these are the key ones which we're going to be addressing today. I'm going to just say a little about the International Court of Justice. It's the one that I'm most involved in, but Neshan is going to do a bit of a deeper dive. But why I'm just introducing that is because it gives you a bit of an idea of how the courts can often go beyond what is just accepted in conventions, treaties, or international agreements. We see this laid out in black and white in the International Court of Justice Statute, where it says that the court, whose function it is to decide in accordance with international law the disputes that are submitted to it, shall apply. And the international treaty is only the first part of that, the international treaties. That's what most people think is the body of international law, but there's a lot more to it than that. They can also apply what's called international custom, which is general practice accepted by law, and there are a number of other ways of determining what is international custom. There's also the general principles of law. This is sort of more the rational approach. What makes sense to be law? What are the general principles that govern the international legal system? And then there's also like precedent, judicial decisions, and teachings. So there's a broad body of law that the International Court of Justice can apply, and that can really help bring in some really interesting and innovative results from cases that are taken to the court. So that's pretty much me. But except I'm just going to add one more thing before I pass on to Neshan, and that's why I got involved in the international tribunals, because I come not as a lawyer. I come as an educator and a campaigner, a peace and disarmament activist. But I saw the value of the courts when I saw the results of some of the cases. Firstly, the nuclear test case, 1974. Australia, New Zealand took France to the International Court of Justice against nuclear testing. Firstly, the atmospheric testing, that was the 74 case. In 75, what happened? France stopped atmospheric testing. We went back to the court on underground testing in 95. The next year, France stopped the underground testing and closed the test site. You can see, as I say, the proof is in the pudding. The impact of the case achieved really what we wanted to achieve, ending nuclear testing. When I started in getting interested in this, I looked at Nicaragua versus the United States. And the general belief of that is, oh, that was a problem because US lost, when they lost the case against Nicaragua, they withdrew their acceptance of the decision of the court. But really what happened in the years that followed is that case was instrumental in helping achieve the Central American Peace Accords. It was that decision was used by Oscar Arias to bring the leaders of the Central American countries together. It gave them the support of Europe, and it also gave the support of the US Congress and other legal developments in the United States, which helped to ensure that that decision was implemented, even though the US government wasn't really interested in the beginning in implementing it. Another case is really interesting. I mentioned Nauru versus Australia. Nauru was basically destroyed environmentally from phosphate mining. This is an environmental case. The interesting thing about this, and this often happens with court cases in domestic jurisdictions, sometimes the court case doesn't end in a final decision because it pushes the parties into negotiating a settlement. And that's exactly what happened here. Australia and New Zealand settled with Nauru and gave compensation for the environmental damage they'd done. And then what was mostly involved in was the advisory opinion on nuclear weapons in 96. This was a citizen-led initiative through the UN General Assembly. We got an incredible decision from the International Court of Justice. The picture you see here is us outside the court as we're welcoming the New Zealand Attorney General, who was one of the speakers in the court. This has been very influential in putting constraint on nuclear weapon states to prevent them moving from a conflict situation to an actual use of nuclear weapons. And this has paved the way for the current advisory opinion, which we'll hear in the next panel, the advisory opinion on climate change. So I relay this because to me, as a non-lawyer coming into this, I see the incredible value of these judicial bodies to be able to take forward key policies and to assist with the campaigns which we are trying to do to make the world better. And that's why I see the engagement of non-lawyers and lawyers, along with other constituents of this as so important. With that, I'm now going to pass over to Neshan. Neshan has had a bit more experience in the International Court of Justice than me because he used to work for Judge Weeramantry, who was a vice president of the court, and can say a little bit more about the incredible value of the International Court of Justice and its cases. Neshan, the floor is yours.
Thank you very much, Alyn. I just wanted to check whether you can hear me. Yes. The great privilege to follow Alyn, and I don't think it needs to be stressed further the importance of the interdisciplinary application for international law and the lived experiences and the inspiration that people like Alyn bring to the implementation of international law and influencing the behavior of states, which I think is at the heart of the wider mission of international law, so that states start behaving in peaceful ways. And with that note, again, thanks to Alex for the wonderful introduction and for the work that Erica has done, and Rebecca, incredible presentation put together, and so happy to support this wonderful panel. I take everybody back very quickly to 400 years ago, almost into 1625, to talk a little bit about origins of interstate arbitration to a prison cell in which a Dutch jurist called Hugo Grotius was writing his seminal work on which is called War and Peace. Now, he was imprisoned for his opinions of the time. As some of you will know, between 1618 and 1648, there were the 30 Years of War in Europe. and it was not the best time for pacific settlement of disputes. But Hugo Grotius, not alone, but his seminal work contributed to what was to come in 1648, the Peace of Westphalia, and the resurgence of the so-called sovereign equality of states here in Europe. And that paved the way for kind of the international legal regime that we consider as the beginning of modern international law. And in fact, Hugo Grotius is referred to in many instances as a father of modern international law. But the beginning of international law goes way beyond that to the 7th, 8th, 9th juristic work of Islamic scholars, such as Ibn Rushd, who was known in the Latinized words as Averroes, and others that contributed magnificent work for international law and treaties. That's one aspect that I wanted to share on the origins. The other goes back to the 24th of August, 1898, where the European powers or the states or the state leaders were invited to the usual briefing by the Russian leadership of the time. And it caught everybody by surprise that rather than the usual briefing, there was a letter of invitation signed by Nicholas II, the Tsar of Russia, basically indicating that all sovereign states should come together to pave the way for a 20th century to be a peaceful century, because the 19th century, building on the Clausewitzian century as a extension of diplomacy, normally leading to war, had to pave a way for a century of peace. And this led to the first peace conference convened at The Hague under the aegis of Princess Wilhelmina, and the birth of the Permanent Court of International Arbitration, perhaps one of the first international institutions set up for peaceful settlement of disputes. I think this conference is of great value. It's 125 years since the 1899 Peace Conference, and this is something that we need to really understand as a step taken at a time to move the 20th century for a peaceful century. This led to a series of events following the First World War. The League of Nations and the Permanent Court of International Justice was established in 1922, which was the predecessor of the International Court of Justice, which was established under the United Nations in 1946. Just to highlight that many sacrifices had to be made for these institutions to be established. And beginning 2024, there is a resurgence of interest in the International Court of Justice and its working. And it's also in memory, we owe a duty to those who have sacrificed their lives to put these institutions together in order to ensure that we move disputes from a violent way of resolving them to a peaceful way of resolving them. And I think that's a key aspect. And finally, this is something we'll probably come back to later in the presentation, is that the San Francisco Conference, which led to the Atlantic Charter and which later on became the UN Charter, the Statute of the International Court of Justice is a part of the UN Charter. So all members of the United Nations who adhere to the Charter of the United Nations become parties to the Statute of the International Court of Justice. Alan, may I go to the next slide? Quickly, a few observations on the composition, jurisdiction, and working methods. It's easy these days. There is a ICJ proceedings can easily be followed online, and I encourage anyone who's interested to follow the proceedings because it's incredible learning, even for practicing international lawyers. But just to give a quick glance at the composition. So as I mentioned, the Statute of the International Court of Justice is part of the UN Charter. The bench comprises of 15 learned judges from all parts of the world. Interestingly, the statute states that in appointing these judges, that their nationalities are not taken into consideration. So it says 15 judges selected with regard to their reputation and moral character and having the necessary qualifications to be appointed to the highest judicial office in their respective parts of the world. And that's actually quite important to understand. They might come from national jurisdictions, but when they are appointed to the International Court of Justice, they become part of an international corpus of law that is applicable across the world. And Article 9 of the statute actually specifies a very interesting aspect, that these judges, when they are to be elected, they not only represent their own civil or common law jurisdictions, they are supposed to represent all forms of civilization and all legal systems, which would include indigenous legal systems and other forms of legal systems as well. Moving on to working methods, a quick glance at what they call interim measures, given that there is a lot of interest on interim measures. Between 1947 May, when the first case was filed in the International Court of Justice, and you see several cases even being filed earlier this year, there has been more or less 10 to 12 interim measures between 1947 and 2000. Between 2000 and 2023, there have been a similar number of interim measures entered into by the International Court of Justice. And just to echo what Alyn said before, large majority of these interim measures has been respected by those parties to these cases. That is one of the most important things that need to be understood. And the interim measures are also a way of quickly addressing possible situations that could really lead to catastrophic ends and trying to mitigate them. So I think that's another important aspect to mention. And on there's a series of cases that have been highlighted. I'm not going to go through all of that. But just to echo the importance of the value of respecting international law, I'll just pick the very first case, which is the Gabčíkovo-Nagymoros project, which is a case between Hungary and Slovakia with regard to building kind of a dam on the river Danube. It was one of those significant cases that took the concept of sustainable development from a conceptual basis to being a strict body of international principles, which led to the International Law Association adopting the principles of sustainable development law in 2002. And Judge Veera Mantri, who was vice president of the court at the time, wrote a separate opinion in this case, which is one of the most outstanding precedents ever set, which looks at to religious, cultural, and philosophical systems which support the basis of international law. So as opposed to 400 years ago when Hugo Grotius wrote his treatise, Judge Veera Mantri and the judges who came during the last 25 to 30 years has expanded the body of international jurisprudence to include cultures and systems from across the planet, including indigenous systems. And I think that's something that has to be highlighted, that it furthers the principles of international law. And if I may just take one other case between Libya and Chad, which was decided in 1994, all over again, over a quarter of a century ago, and quite relevant in the discourses of today. There was a dispute between those countries with regard to a small strip of land called the Aouzou Strip. Now, the Libyan army was massive. The country was massive. Chad was a small country with almost comparatively a very small army. But they decided to go to the International Court of Justice. The International Court of Justice held in favor of Chad, going into historical records, saying the Aouzou Strip belongs to Chad. Now, Libya, what could they have done? They could have ignored the International Court of Justice and said, oh, no, we are not threatened by Chad. We can do whatever we want. But what actually happened was Libya respected the International Court of Justice opinion, decided with Chad to ceremoniously remove the Libyan flag from the Aouzou Strip and host the Chad flag, and marched out of that strip, allowing Chad to move in and take occupation of the land that belongs to them. These are examples of, unfortunately, hasn't had much media coverage, but we should know that this is actually how international law is respected. Should have Libya violated that opinion, maybe we would have much more coverage on these issues. But I think as international lawyers and educators, it's imperative that we sell these aspects or these examples to further international law and its application. And finally, just to kind of wind up this part of the focus of international courts, the jurisdiction involves contentious issues, advisory issues on legal matters that the International Court of Justice could deliver, as well as interpreting treaties. And finally, the compulsory jurisdiction of the International Court of Justice. Right now, out of the 196 countries, there's 74 countries that have adhered already to the International Court of Justice. But remembering that all members of the United Nations are party to the Statute of the International Court of Justice, there is a imperative to recognize the compulsory jurisdiction of the International Court of Justice. And this is a matter that we will come back to later on. And this is just the final point is to highlight one of the criticisms of the International Court of Justice is saying that it does not have an enforcement arm or an army to go around to ensure that the International Court of Justice opinions are respected. But I think that's will be futile to the memory of those who have already sacrificed their lives to build this future for us. It is not about having an army to enforce international law. It's about respecting the international rule of law and the principles that have been achieved after much sacrifice. Thank you very much. And I hope to connect after Rebecca.
There she is.
Of course, my internet went out just queued up.
Search my participants. I thought she escaped.
Oh,
Rebecca, you're frozen. I don't know if she can hear. Hi, Rebecca.
It's always a privilege to speak with my friends and colleagues, Neshan and Alyn. I think this piece, this whole panel, actually, before I get started, is a wonderful companion to our opening from Rita and Andreas. If we consider
What wonderful timing. Rebecca's been in the whole time and had no problems, and she's coming in and out.
I was saying that I think this panel is a wonderful companion to the way we started today with the wonderful presentation by Andreas and Rita on a UN Parliamentary Assembly. Because if we look at a democratic world federation as a totality, as a holistic system, we need the checks and balances that we're so familiar with studying in civics and in history classes and social studies and governance at the domestic level. And so if we look at the international governance system today as primarily executive driven, a powerful legislature and an equally powerful and accountable judiciary is paramount importance. If I have any goal for my section here, it is to dispel some of the misconceptions, which are pretty rampant and persistent, about the International Court, Criminal Court, and hopefully we'll have a rich discussion. I'll start a little bit with the history, and I hope not to be too pedantic or too boring here, but I think it is necessary to understand how the ICC came into being, especially as Neshan has given such a rich background to the origins of international law. And by comparison to the International Court of Justice and its predecessors, the ICC is a fairly recent innovation, and I think gives us hope for how quickly actually international democratic governance can change. And here I recall the words of the former UN Secretary General Kofi Annan about the court, that this cause, the cause of creating the ICC, is the cause of all humanity. And so the establishment of the ICC can be traced back to various historical events, but I'll situate us first in the post-World War II tribunals. And so following World War II, the international community came together to establish the Nuremberg and Tokyo tribunals to prosecute individuals who were responsible for crimes against the peace, war crimes, and crimes against humanity. That was the jurisdiction of those two tribunals. And they marked the first instances of international criminal justice and laid the groundwork for future efforts. I distinguish international criminal justice because what Neshan has just given you as an overview of the ICJ is justice among and between states. And international criminal justice is justice over individuals for specific crimes. And we'll talk a little bit more about what the current jurisdiction of the ICC is and how those crimes are defined. So in the 1990s, in response to the atrocities being committed in Rwanda and the former Yugoslavia, there were two ad hoc tribunals that were established, the International Criminal Tribunal for Yugoslavia and the International Criminal Tribunal for Rwanda. And they really demonstrated the international community's commitment to deal with these issues in a judicial way, in addition to various peacekeeping and military interventions in both of those conflicts. They live on today, actually, in the residual mechanism for the International Criminal Tribunal, which has concluded its proceedings, but there's still some upkeep and housekeeping that's being done, which gives you a sense of kind of the longevity or the tenure of some of these proceedings. So the Rome Statute, that is the foundational treaty of the International Criminal Court, was established came to being in 1998, but it was actually the subject of many extensive negotiations between New York and Rome and capitals, et cetera, over decades. And civil society played a critical role in this process. Some of you may be familiar with the name Bill Pace, who was the former executive director of WFM and the initial convener of the Coalition for the ICC. And it would not have been without civil society that we could bring states to the table to at times have very contentious discussions over very thorny issues. And some of the big issues in Rome ranged from jurisdiction. Some countries like mine, I join you from Washington, D.C., the United States, which is not a state party to the Rome Statute, not a member of the ICC. We're very concerned about the ICC's potential to infringe upon their sovereignty. And in the United States, there is a very complex history that maybe we'll get into in the discussion of our relationship with the court, definition of crimes. Going into the genocide was clearly defined, and the definition in the Rome Statute mimics that of the Genocide Convention. However, crimes against humanity and war crimes were not as clear. And moreover, they're evolving all the time, as I will continue to discuss, I think, in this session. There was a lot of debate, for example, over whether to include terrorism or drug trafficking or corruption within those crimes. They do not currently exist within the Rome Statute. Another contentious issue was immunity, whether there should be immunity for heads of state. There is not. Another one would be the death penalty. The death penalty is not an enforcement mechanism or a penalty envisioned within the Rome Statute as such, despite the wishes of some states that that have capital punishment to do so. And the work didn't really end at Rome because the Kampala amendments, which were envisioned originally in the Rome Statute, there was always going to be a conference to consider the crime of aggression, the fourth crime under the court's jurisdiction. But those did not come to be iterated until 2010, called Kampala Amendments, because the conference took place in Uganda, and they did not come into force until 2018. And so these consider how the crime of aggression would be articulated. And only after 60 states parties to the Rome Statute accepted the definition arrived at in Kampala, Uganda, did in 2018 the crime come into effect. Next slide, please. So before I get into some technicalities, just to give you, and this might be a little bit drier, but I think it is important to give some of the working methodologies. I will say that the jurisdiction of the court is probably one of the most important developments of international law in our time, and it's continuing to evolve. So regarding jurisdiction, I'm going to go to that first, then I'll talk about composition a little bit. Sorry, I gave this in the wrong order on the slide. I mentioned that there are 4 crimes within the court's jurisdiction. Those are genocide, crimes against humanity, war crimes, and the crime of aggression. And these continue to evolve. For example, the current prosecutor has said that cybercrime can be considered a crime against humanity and a war crime within the current definition of the Rome Statute without the need to amend it. Crimes of a gender and sexual nature also continue to evolve in their iteration. There is also a movement to evolve and amend the Rome Statute to include new crimes altogether, such as the crime of ecocide. And here I think the next panel will pick up very well from where we leave off. Further from the subject matter jurisdiction, those 4 crimes, and each of them has elements and an articulation. We can share the Rome Statute in the chat so you can actually see what it is for yourself. There is the matter of territorial jurisdiction. So to date, 124 states parties have accepted the jurisdiction of the court. It was 124, then 123, because one state, Burundi, withdrew. Now we're back at 124 with a very recent accession of Armenia to the Rome Statute system. The cases before the court have to contemplate a situation that existed on the territory of a state party or was committed by a national of a state party, unless a state under Article 12.3 accepts exceptional, it's a tricky one to wrap your mouth around, jurisdiction, as was the case recently with Ukraine. The composition of the court. There are 18 judges who are elected to 9-year non-renewable terms. The prosecutors also elected to a 9-year non-renewable terms. And there are several stages of proceedings that may be a little bit unfamiliar to those of us from common law jurisdictions. So to reach the court, first, there are 4 ways to reach the court. One is referral by states, and often that includes state parties. So many cases, self-referral by states parties. It can only be referral by states parties generally, but I would say about 80% of the referrals by states have been by the states themselves that are concerned of the case. The second is by the Security Council, referral by the Security Council, and that's happened twice to date in the situations of Darfur and Libya. The third is a little bit of an asterisk on these 2, and it is about the crime of aggression. So since 2018, when the crime of aggression came into effect, the Security Council can refer cases exceptionally where aggression has been deemed to occur, where there is not a state party involved. So this is a big asterisk and is still being worked out, and it hasn't yet happened. And the fourth is proprio motu. And what that means is by the prosecutor's own discretion, opening a case. And this has been pretty rare, actually. I believe there have been 11 so far in the history of the court, as opposed to the number that have been by self-referral or the 2 by UN Security Council and 2 by states parties, the situation in Ukraine and Venezuela. Just by the numbers, there have been 12 investigations. There are 12 investigations ongoing, 3 preliminary examinations, 40 arrest warrants have been issued, 31 cases, as I said, brought before the court, 5 persons in custody, 15 suspects. The court has 900 staff members. That seems like a lot, but I looked it up and there are more than 500 staff members of my country's Supreme Court of the United States, more than 200 in Canada's Supreme Court. When you consider this contemplates roughly 2/3 of the UN states parties, the numbers kind of, you see a little bit of dissimilarity there. And the operating budget, because I get asked this a lot, for fiscal year 2024 or the operating year 2024 is about 187 million euro. I will just say a little bit about working methods. As I said, this might be a little bit distinct for those of us from some common law jurisdictions, because there are a number of phases before you even reach the trial phase. First, there is a preliminary examination that may happen by any of those methods that I just mentioned, which considers whether or not there's appropriate jurisdiction based on subject matter, based on territory, whether or not there is sufficient gravity, and whether there is an interest of justice, that is the phrase that is used, to pursue the case. Next, if the prosecutor decides in his or her wisdom that those criteria are met, a pretrial chamber makes a decision about moving forward with an investigation. And should the investigation yield sufficient evidence connecting the burden of proof to specific individuals for specific crimes in the Rome Statute and under the court's jurisdiction, then we have a case. And this little photo, I think, is the case of, this was actually a post-trial proceeding in the matter of Jean-Pierre Bemba, former defense minister of DRC, who was charged and then ultimately acquitted of crimes against humanity committed in the Central African Republic. And if you can see that little clerk on the right in the front, that might be a familiar individual. I won't go too much more into the detail of working methods. I'm happy to engage with that later, but I want to get on to some of the more perhaps controversial subject matter with the court. So next slide, please. So some of the major contributions of the Rome Statute have been defining these crimes. As I said, while genocide has been defined, and perhaps the definition needs to be updated since that was iterated in the treaty more than 70 years ago. The definition of war crimes and crimes against humanity, and certainly the crime against aggression, has been an innovation of the court. Complementarity. Complementarity is the premise that the ICC can only take a case if a state is unwilling or unable to have prosecuted these crimes domestically. Moreover, there's something called reverse complementarity. There are many states parties, and actually a few non-states parties, that have internalized and domesticated these atrocity crimes within their frameworks, thanks to the definitions laid out by the Rome Statute. So this is actually strengthening national law. Victim participation. At an ICC proceeding in the courtroom, you were only seeing the bench. There are three sides. There is the prosecution, there is defense, and then facing the judges are victims' representatives. Victims are not part of the prosecution. They are given their own rights and their own counsel under the ICC system. And this was incredibly new. This was not even a facet of the ad hoc tribunals. Cooperation, coordination among states, and then advancement of legal policies. And these are ongoing. In fact, this week, I think we'll see next steps in civil society contributions on the OTP, the Office of the Prosecutor's policy on gender and sexual crimes. Now, on the other side, we have a lot of persistent criticisms and challenges that the court faces. And some of these are earned and some of these are not. The first is the impression of selective justice, primarily since so many of the early cases and situations before the court continent. I mentioned the ways in which situations and cases reach the court. When you realize that very few of those cases actually came proprio moto, almost all of them were self-referrals, that changes the dynamic a little bit. And I'm happy to get more back to that. The last prosecutor was a national of the Gambia, and had a lot to say on this. And the president that I served under when I served in chambers was a national of Nigeria. Limited enforcement mechanisms. The court depends on states to arrest, detain individuals and suspects. The limited jurisdiction, both in terms of subject matter and the number of states that have acceded to the Rome Statute, which is why we continue to work towards universality. Resource constraints. I mentioned above the budget of the court and the number of staff might seem a lot, clearly not in the scheme of things. And then in terms of the perception of politicization, in addition to the bringing of cases before the court, there are claims about the lack of independence. There have been claims about the lack of independence of the judiciary. I don't think that those are valid, but greater steps have been taken in recent years and led predominantly by civil society as well, to ensure that judges are of the highest caliber. The election system for judges is incredibly complex. I don't have time to go into it, I think, on this slide, but if it comes up in discussion, I'd be happy to. The complexity and length of proceedings, we talked about there being 31 cases in the court that's been active since 2002. That's not a lot, maybe, but to some. But when you consider the gravity and the number of witnesses and the thousands and thousands of testimonies that need to be taken under very difficult circumstances, sometimes in cases of ongoing conflict, you can get an idea as to why. And then inconsistent judicial standards. I'll be honest, this is something that I witnessed myself when I worked in chambers. You have judges from all sorts of legal backgrounds, and harmonizing that and coming up with judicial practices that are consistent while reflecting the expertise and the variety of legal traditions has been a challenge. This is being codified to a greater and greater extent every year, and we definitely see the court as a work in progress. Next slide. So I think with that, I'll end my discussion of the ICC. So we have time to briefly delve into some other courts and tribunals, and of course, time for discussion. I think Alyn needs to be unmuted. Okay.
Thank you. Yeah, we can't unmute ourselves. Thank you. We'll have to go quite quickly through the last section because we need a little bit of time for questions and answers. But I think it was valuable to have this deep dive into both the International Court of Justice and the International Criminal Court, because there are a lot of myths and misconceptions about these two tribunals. And mostly these myths and misconceptions are spread by elites and powerful countries that want to avoid responsibility under the tribunals. So they spread these and people sort of pick them up because they don't know enough about them. So I think that deep dive has showed you how valuable these courts are, how that the process for setting up the judges is pretty good. It may not be perfect, but it's pretty good. That the judges in the tribunals are pretty much independent, that they are taking into consideration the facts and the law, that these systems are also done consistent with national judicial systems. They're not a replacement. And so that connection between the international tribunals, national law, regional law is really important to these. So I think it's a really good basis then to be able to build the support for both of these tribunals and help move the key campaigns for universality, to get those states which haven't accepted or haven't ratified the International Criminal Court to do so, and also to get those states which haven't accepted the compulsory jurisdiction of the International Court of Justice to do so. We'll quickly mention a couple of the others. The International Tribunal of the Law of the Sea, because it's playing such an important role in managing territorial space in the oceans and resources in the oceans, and now also other environmental issues like climate change has come through the International Tribunal on the Law of the Sea. And again, some of the same sorts of processes and principles as we've seen in the International Court of Justice and the International Criminal Court are playing out in the International Tribunal on the Law of the Sea in order to help resolve a lot of these conflicts and protect the oceans. The Permanent Court of Arbitration, Neshan has already talked about, but it's useful just to mention again, because in the UN Charter, there is a requirement for member states to resolve their conflicts peacefully. That's Article 2. And then in Article 33, it talks about the ways that you can do that. And this includes negotiation, mediation, arbitration, and adjudication. And as you see, they're at different levels. The first step, of course, for conflicts is try to negotiate. If that doesn't work, mediation is really good for bringing a third party. If that's unable to work, arbitration is a slightly stronger mechanism because it's a binding outcome under the agreement. And the Permanent Court of Arbitration was the first international tribunal. So it's had a good track history of resolving conflicts between countries. But the most powerful, of course, is the adjudication. And that's where it's so important. When conflicts aren't able to be resolved in other ways, or sometimes even to kickstart the process, if going to the International Court of Justice or the International Criminal Court is really, really important processes for that. What was the next part? I think this is Rebecca. It's just talking about some of these other courts and tribunals.
we may need to segue to the Q&A. If you want to do a brief summary, I just want to leave at least
I'll
10 minutes.
summarize this in 2 sentences, 3 sentences. So in addition to the standing bodies, and while the topic, or I think the session was titled International Tribunals, what we've been talking about actually is international courts. These are primarily international tribunals because they have a more specific focus, are of a hybrid nature. And what that means is that they incorporate elements of domestic law and international law and are based, they can be based in the country of interest, or they can be based elsewhere. 2 examples: the Extraordinary African Chambers was the first time that an African head of state had been found guilty of atrocity crimes by another African nation. This was in Senegal, where Hissène Habré was found guilty of crimes against humanity and war crimes when he was the Chadian dictator. Whereas the Kosovo Specialist Chambers is actually located in The Hague and applies Kosovo law for alleged war crimes and crimes against humanity committed during the conflict from 1999 to 2001. And it's a way for justice to be both domestic and close to home at the same time as applying principles and expertise of international law.
Do we have 30 seconds for Neshan on the regional courts?
We got 30 seconds for Neshan on the regional courts. Go right ahead, Neshan.
Thank you. Just to kind of echo what Alyn said at the beginning, and Rebecca, also mentioned in the presentation, the regional courts are set up by regional conventions and treaties, but we need to take the international system together. There is momentum between and a conversation that goes on between what goes on at the international level and regional courts, such as African Court, the European Court of Human Rights, and Inter-American Court of Human Rights. And of the many ongoing overlaps, I think the number of advisory opinions on climate change has to be mentioned, because that is something that affects not only us humans as one species on the planet, but everybody else. Thank you.
Thank you very much. So we should open up to questions now.
All right, wonderful. Let me add myself to the spotlight. Thank you so much for that presentation. You went through a lot of content, and I am really appreciative of the in-depth nature of your responses. So I want to kick it off by asking a little bit about your thoughts on the limitations of jurisdiction. So you mentioned that drug trafficking is not included. How do you think this impacts the effective nature of the court? Do you think it's a shortcoming or an advantage? Rebecca, we can start with you.
Thanks. Well, we didn't have time to explore our proposals for new courts because there are lacunae, there are gaps in the international legal system. Regarding drug trafficking, there is a lot of international cooperation at the transnational level. You have Eurojust, you have Interpol, you have bilateral agreements. But when you take an area like corruption, for instance, which is a very complex crime where a lot of domestic jurisdictions both are unable to prosecute and sometimes actually having worked previously with anti-corruption prosecutors and officials in unfriendly home environments, their own bosses are the ones that are that should be targeted. And this is not a crime under the Rome Statute. It is not generally a crime in the ICJ because it's not generally an interstate dispute. You can see how maybe it could be. Where do corporations come in as defendants as well as individuals? So there is currently a proposal, and we'll put links into the chat, for an international anti-corruption court. And this is gaining a lot of momentum. It's been signed up to by, I think, 30 or 40 states and numerous eminences from around the globe. It's championed by a federal judge here in the United States, Judge Mark Wolf, and Justice Richard Goldstone, who might be a name that's familiar to many of you as a champion of international justice from South Africa. There are other proposals on the table as well. We mentioned the regional court system that deals with human rights being distinct from either ICJ or ICC jurisdiction because they deal with the rights of an individual against their state. But those only embrace the inter-American system and not all North American and South American and Latin American nations, the European system, and to some degree, the African system. That leaves a lot of the world out. So there's a World Court of Human Rights proposal. And also, as we'll hear, I think, in the next panel a little bit, there are proposals for an independent climate governance commission or climate governance court or tribunal to deal with all the multivariate issues that arise in terms of environmental governance.
Neshan, Alyn, thank you for that, Rebecca. Anyone want to provide comment first? Neshan? Okay. No? Okay.
I'll just, Erica, for
Go
people to look into the chat, because I put the links to the proposal for the International Anti-Corruption Court, and also the link to the proposal for the International Court for the Environment. So they're in the chat, and also the link for the global campaign to build acceptance of the jurisdiction of the International Court of Justice, which is called Law Not War, Legal Alternatives to War. And if people are really interested in that, we are having a meeting of the participating organizations on Tuesday, and people can just find the information on the Law Not War page.
Yeah, if I might just come back, whilst it is important to have international tribunals to deal with transnational issues, we must also look at the other way around. For example, the ongoing cases on South Africa versus Israel before the International Court of Justice has all these national jurisdiction. For example, in the Netherlands, last week, they sued the Dutch government for having agreements on defense agreements with Israel, and a Dutch government, the national jurisdiction said you have to stop these agreements because you could be complicit in committing violations under international humanitarian law. There are many, many such examples that we need to look at this complementarity at the national, the regional, and international levels as we deal with more and more transnational issues, which I think increasingly most, if not all, are transnational issues.
Thank you for that, Neshan. Rebecca, I saw you had your
Yes,
contribution.
thank you. I keep forgetting I should just stay unmuted.
Stay unmuted, please.
So there's another element here that complements what Neshan just said about domestic jurisdiction, which is the increasing use of universal jurisdiction. And we've seen this in novel ways by several countries where there isn't an immediate pathway. For example, they don't have the territorial control over a subject who is alleged to have committed some of the atrocity crimes, or there is a massive corruption issue. And so we've seen particularly European states, but I think in a couple occasions Canada as well, exercising universal jurisdiction. And this is gaining steam in terms of compulsory international law. And it's gaining acceptance. And all of these pathways are complementary and not competitive. In many of the cases that might be of interest to you, Ukraine, Israel, that are very much in the news, there are so many different avenues that are being pursued. If I take a different one, Myanmar, for instance, there's currently a case before the ICJ on genocide. There's currently a case before the ICC on the crime of deportation. There's currently the independent investigative mechanism for Myanmar of the UN, which looks at all crimes allegedly committed by the military, and not just against the Rohingya people, for a longer period of time, I think since 2011. And so these coexist rather than conflict.
Okay, yeah, there is a question in the chat, somewhat related. What is the policy of international courts and tribunals on terrorist organizations, such as ISIS, Al-Qaeda, and they list Hamas as well? What are some of the, how do they factor in?
While terrorism isn't a crime in the Rome Statute, the crimes that emanate that have been committed by ISIL Daesh of crimes against humanity and in some instances perhaps war crimes are, and there is a situation under investigation in the investigative stage in Iraq that contemplates war crimes and crimes against humanity committed not only by what I guess might be called terrorist actors, but also by the coalition of the willing that engaged in the conflict. So while terrorism is not an independent crime, I think many of the acts are already crimes within the Rome Statute. There is a question about jurisdiction, especially with the ICJ, because these are not state actors, and to elevate them to the level of a state would be in some ways to give them to give them legitimacy. And actually, this is something we saw with Myanmar, that the ICJ made a very preliminary decision that by hearing arguments from one side, from the current government of Myanmar, it was not acknowledging that the junta is a legitimate government of Myanmar. And so that comes up with ISIL Daesh. With the ICC, there's the further problem that you really need to be able to collect evidence. And so while there is an investigation ongoing for these crimes, it's very difficult in an active conflict zone. And there has not been, for that reason, really, a furtherance of issues in the Syrian Arab Republic, for instance. And this is, of course, to the deficit of many ongoing victims and survivors.
Alyn, thank you for sharing the treaties on terrorism. Please share your thoughts.
I'll just add a little bit to that, Erica. So there are about 15 treaties that deal with state responsibility to prevent terrorism. And there's also some UN Security Council resolutions that deal with state responsibility to prevent various terrorist acts. That includes, hijacking airplanes, and includes providing nuclear materials to non-state actors, financing of terrorist organizations. There are a range of them. So there is state responsibility. That state responsibility can be tested in some of the international tribunals, but it's not comprehensive yet. And that's partly due to the fact that not all those conventions do have reference to jurisdiction of the International Court of Justice. They're very light on that. So there have to be other avenues, primarily, through the avenue of the general acceptance of jurisdiction of the court. And secondly, because there's still some, as Rebecca mentioned, there's some difficulties in how to look at the criminal responsibility of those actors themselves under international law. So there's gaps, but it's not absent. And there are ways of taking some of these issues up in the international tribunals.
And I would just say that part of the reason it's absent is due to the politicization of the term terrorism. And this is why it has been an incredibly controversial subject under international law.
Thank you so much for those responses. We do have 1 minute till the next section. So thank you, Shamel, for that question. And thank you to our presenters. Again, a lot of really wonderful content. And I think there's still some questions in the chat. So maybe I'll try and field those and send them to you in a follow-up email, because I know you have a lot of links and a lot of knowledge to share. So thank you for all the work you did for your presentation. Thank you to everyone in the chat still asking really wonderful questions and keeping this discussion going.